right, so this is the review for Test 3, and the coverage of Test 3 is chapters 12 through 16 in your book and in your handouts. Please pay close attention to items that I have underlined or bolded on this review. There are 40 questions worth 2.5 points each, and of course this test is on Canvas with Honor Lock. So let's get started. We discussed adverse possession as one of the topics in this material, and adverse possession is a way for you to acquire title to property in an informal way. In Virginia, the statute is 15 years, and so if you possess the property of another for 15 years openly without permission of the owner, and it's continuous and exclusive, then you can claim it as yours. Tacking is allowed, and all that means is that you can add the time that you have possessed the property with perhaps a prior owner. So let's say that I adversely possess a strip of property for 10 years and then I deed my property to my son and he adversely possesses that same piece of property for 5 years. He can add my 10 years to his 5 years and that property is then his. All right, so let's move on. The listing agreement itself. In Virginia, with written consent, a real estate agent may actually represent both a buyer and a seller. I have a problem with this because it's a dual agency, and I don't know how you can represent both a buyer and a seller who have differing interests, but you can with full disclosure. Couple things for you to remember. Your listing agreement should have a specific termination date, a specific date. A person may sell real property without a license under certain circumstances, and I've listed those on this slide. So if you're selling real estate for yourself, or if perhaps you're an attorney and you're selling it for a client, or if you are acting as a personal representative, let's say an executor or an administrator of an estate, or perhaps if you are a public official and you are dealing with the sale or the purchase of property pursuant to your official duties, you would not have to have a license. All right, a couple things to note about the condition of premises. In Virginia, new construction has an implied warranty that the dwelling is free from structural defects. Other than that, you're pretty much caveat emptor or buyer beware. However, be aware of a situation where someone has tried to conceal a defect or misrepresent the condition of the premises, because this could arise to fraud. So active concealment of a latent defect or a misrepresentation of the condition of real property may impose liability for fraud on either the seller or the seller's agent. And simply because you're selling property as is would not insulate you from liability for fraud. All right, so there's some things that a licensee, a real estate agent should reveal and some that they should not. All right, in Virginia, should you reveal that a suicide has taken place on the premises? And the answer is no, not without the permission of the seller. How about you know that the foundation is cracked? Absolutely yes. How about this, a wet basement? Yes. How about the seller has AIDS or HIV or previous owner or previous occupant? And the answer is never. Purchase contracts. A contract for the sale of real property is just like any other contract in that it must state the agreement between the parties and have enough information to identify what the essential terms of the contract are. It doesn't have to be drafted by an attorney. So we say it may take any form. If you are a licensee, you probably will use the REB form. However, that's not required. Potential pitfalls in writing a contract for the sale of real property is that without a provision in the contract, as soon as the contract is signed, the risk of loss passes to the buyer. So we say that as soon as the buyer signs the contract, the buyer has equitable title. And so watch out for that very situation. The role of the licensee. So a contract may be written by the licensee if it's done in connection with other services. So for instance, if you have the listing on the property, a licensee may never write a deed and licensees and lay settlement agents may not advise as to how to hold title to the property that's being purchased. All right, we talked a little bit about the Interstate Land Sales Full Disclosures Act. There are certain exemptions, but this act regulates sellers of undeveloped properties, and it applies to the sale or lease of 50 or more unimproved lots. If you're involved in that sort of a transaction, then this law applies to you. The act requires sellers to file a statement of record and to provide certain disclosures to buyers. And this is to give them full disclosure, and it's an effort essentially to level the playing field. Note that there are both civil and criminal penalties for developers if a developer fails to comply with the act. All right, so closing the deal. Just a warning to you, a seller must always sign affidavits or sworn statements. A seller would not be allowed to, or any party to a real estate transaction would not be allowed to have an attorney-in-fact or a power of attorney sign sworn statements or affidavits. RESPA provided a couple of changes to our laws. RESPA prohibits sellers from requiring buyers to use certain title companies. In the past, that had been a problem. It also outlaws referral fees paid by settlement agents, and it requires a good faith estimate of closing costs prior to settlement. CRESPA is the law that gives buyers the right to choose the settlement agent. And again, in Virginia, your settlement agent could be an attorney, and it could be a lay settlement agent. If you use a lay settlement agent, I need to point out that all settlement agents must be registered with the Virginia State Bar, even lay settlement agents. Settlement agents must carry errors and omissions policies. That's a malpractice insurance of at least $250,000, and also maintain a surety bond of at least $100,000. Your settlement agent is also required to have an employee dishonesty policy to cover any other employees of at least $100,000. A settlement agent is not allowed to earn any interest on funds that are deposited in their trust account in connection with the settlement. A deed of trust. You know, when given the choice, a lender prefers a deed of trust. A deed of trust is a three-party instrument where legal title is vested in a trustee. And what happens is that if there is a default, the property is sold pursuant to the power granted in the deed of trust. As I said, lenders prefer deeds of trust. It's because if there is a default, the deed of trust gives the lender the right to accelerate the loan and secure payment much faster than if a mortgage had been used. A couple of things with respect to financing that you need to remember. A point is 1% of the loan. And if writing a contract, a real estate licensee should ensure that if money is being borrowed and a deed of trust is being used, then that contract should be contingent on financing. It should be contingent on perhaps a ceiling on the interest rate and the type of financing that the purchaser intends to use. My note to you is this, that if a loan is being sold outside Virginia, the note that goes along with the deed of trust must be notarized, and it must have a seal on it, a notary seal. Lenders. The lender is going to prepare both the deed of trust as well as the deed of trust note. On a first deed of trust where the rate is stated on the loan agreement, there is not a maximum interest rate allowed by law. Late charges. What if you're late on a payment? Well, late charges may not exceed 5% on a mortgage loan, and late charges may not be collected unless the payment is at least 15 days late. My note to you is this: most lenders do allow 15 days, but the law says at least 7 days late. the deed. So that's the document that transfers title from the grantor to the grantee. In order for a deed to be effective, the grantor, that's the person conveying title, must have capacity, and the grantee is the person to whom the property is being conveyed. The deed is going to contain a recitation of nominal consideration, not the purchase price. The purchase price does not have to be included in the body of the deed. It will also contain a granting clause, and it must have an adequate legal description. One of the least desirable methods of describing property is street address, and the reason, remember, is that street addresses can change over time. So a valid deed must contain a description of the land. The actual purchase price is not required, and that's one of the questions on the test. The grantor's signature, all of the grantors must sign the deed for it to be effective, and failure to sign would invalidate a deed. From the standpoint of a buyer, the best way to hold title is to obtain a general warranty deed, and you'll need to remember that too. Transfer of title by deed. One of the things that you probably learned is that recording is not necessary to transfer title between the grantor and the grantee. But here's what you do have to have. You must have delivery with intent to transfer title. I will tell you that almost always deeds are recorded immediately because you want to protect that interest in property. You want to make sure that the grantor doesn't convey the same piece of property to someone else. All right, how about this? Can the grantor and the grantee be the same person? And you found out the answer is yes, and the example I gave you in class was that my parents owned a piece of property, and they owned property as tenants in common. My father wanted to own the property as tenants by the entirety. So as tenants in common, they executed a deed to themselves, so they were the grantors, and the deed then made them tenants by the entirety. The other thing that I need to point out about deeds and recording fees is that if I were to ask you what is the fee that sellers generally pay, the seller generally pays the grantor's tax. Of course, you could negotiate other things that the seller would have to pay, but as a general rule, the seller pays the grantor's tax. And if you'll remember, in Virginia, it is $1 per thousand. And so that's one way that you can determine how much the buyer paid for a piece of property. That will be printed on the deed. All right, so that's it. So good luck on test 3. Again, there are 40 questions, the same format as before. True, false, multiple choice, and a few matching. Each question is worth 2.5 points. It's on Honor Lock. The test is on Canvas. Best of luck. Thank you.